Hi everyone and welcome to Series 2 of the World of Employment Law. So we had a bit of a discussion within the team as to what topics we thought we should focus on for this series and have decided that we're going to look at different types of family-friendly leave in the workplace. So as you're probably aware, there are several different types of family-friendly leave. So you have maternity leave, paternity leave, adoption leave, shared parental leave and dependence leave are current existing ones that are in force. And we've also got the new type of leave, which is carers leave, which has come into force in April 2024, and neonatal leave, which is due to come into force next year. So we appreciate with a lot of different types of leave, it can get confusing. And we often have questions from our clients as to what type of leave would be the most applicable, depending on different situations, and what are the requirements for types of leave, such as notice or any entitlements to be able to qualify for types of leave. There's also been quite a few changes this year in terms of family-friendly leave, with a raft of changes coming into force in April 2024. So what we thought we'd do for the first episode of the new series is to focus on the changes which came into force in 2024 April time, and in respect of the existing types of leave. So that's in terms of flexible working, maternity leave and changes in respect of that, and also paternity leave. I'll pass you over to Sophie now, who's going to talk you through the enhanced protection in respect of redundancy for different types of leave.
Thanks, Jen. Hello, everyone. So as Jen mentioned, I'm here today to talk about the enhanced protection that's now given in redundancy situations. So as of the 6th of April, the law with regards to suitable alternative roles in redundancy situations has changed somewhat in relation to some types of family-friendly leave. Now, what has changed is the time frame of protection that's offered, and I'll talk you through that in a moment. But before I do, I just want to talk about the type of protection that's offered in redundancy situations. So previously, an employee who was on maternity leave had priority status in respect of suitable alternative vacancies in a redundancy situation. So what that means is when an employer is undergoing a redundancy process, they have a legal obligation to consider whether there are any suitable alternative vacancies for employees who are at risk of redundancy before making them redundant. And previously, employees who were on maternity leave had essentially first refusal for suitable alternative vacancies only while they were on maternity leave. Now, since the 6th of April 2024, the timeframe has been significantly increased. So who does this apply to? It applies to anyone who is legally classed as an employee, so not workers, only employees, and applies to anyone who is pregnant, taking maternity leave, adoption leave, shared parental leave, and it also applies in the very sad cases of miscarriage and stillbirth. So many employers sometimes ask, well, am I allowed to make somebody redundant if they are pregnant or if they're on maternity leave or shared parental leave? And the answer is yes, you still can make them redundant. But what's really important is that they are given that priority status for suitable alternative vacancies. And if employers don't ensure that they uphold that right for those individuals, there could be potential litigation risk, for example, discrimination on the basis of sex, discrimination on the basis of pregnancy or maternity leave. So it's really, really important that employers are aware of this obligation. So what is the length of the protection in redundancy situations? So in relation to pregnancy and maternity leave, the protection actually now starts when the employee notifies their employer of their pregnancy, not when they start their maternity leave. And it ends either 18 months from the expected date of childbirth or the actual date of childbirth. And in relation to adoption leave, the protection starts when adoption leave commences and ends again either 18 months after the date on which the baby is placed with the parents or the date on which they enter Great Britain if the child is being adopted from overseas. In relation to shared parental leave, the protection will begin when shared parental leave commences. If that period is less than 6 weeks, it will only last for the duration of the shared parental leave. But if the individual is taking more than 6 weeks continuous shared parental leave, then they will actually get protection from 18 months from the date of birth. And finally, in the very unfortunate cases of miscarriage and stillbirth, if an employee suffers a miscarriage, then their protection will end 2 weeks after the miscarriage occurs. And in cases of stillbirth, if the pregnancy ends 24 weeks after gestation, then the employee would actually be entitled to maternity leave. So they'd get that protection for the same amount of time as somebody on maternity leave. So some interesting facts that were taken from government research, which we used to guide the new legislation, that 70% of mothers reported negative and possibly discriminatory behaviours from their employers throughout their pregnancy or during or after maternity leave. And similarly, 20% of mothers were made redundant at some point during their pregnancy or maternity leave.
The employers now, if they receive a statutory flexible working request, must respond to that within a 2-month period. So again, that's a change from the previous legislation, which allowed a 3-month period, what we call a decision period, in order to provide an outcome to the request to an employee. So that's shortened, and employers need to make sure they're aware of what date the request is made and what's the final date on which they will be able to confirm their decision. Employees no longer have to explain or justify the impact of the proposed change to their working arrangements. So previously, employees would have to explain as part of their application and making a flexible working request on what impact they felt that would have on their employer and their business if they wanted to make that change going forward. That's no longer required. That still might form some discussion as part of the consultation with the employee, but they don't legally have to make that clear on the application itself now. And finally, employees must be consulted before their request is refused. So previously, there didn't have to be a meeting with the employee for a refusal of a request, but now that is required if an employer doesn't consider they're able to make the request the employee is asking for. Now, it's important to bear in mind that the reasons for refusing a statutory flexible working request haven't changed. So there are still only 8 reasons in law for which a statutory flexible working request can be refused, which include extra costs that will damage the business, that work can't be reorganised among other staff, that individuals can't be recruited to do the work, that the flexible working request would negatively affect the quality of work, the flexible working request would negatively affect performance, that the business wouldn't be able to meet customer demand, that there would be a lack of work available during the proposed working times in accordance with the request, or finally that the business is planning changes to the workforce that wouldn't align with the request. So those 8 reasons for refusal still exist. They haven't been expanded or changed at all. And employers need to make sure that if they do refuse flexible working requests, that there is a legal definition that they can fall under to make that refusal lawful. Now, in terms of what steps employers should be taking due to the changes, there's the standard things that we always say of making sure that your policies and procedures are up to date. It's important their employees are aware of the changes to their legal entitlement to make a flexible working request. So perhaps there will be training undertaken within the business for all employees, especially those that might be dealing with the requests as well. What we've seen from surveys conducted by ACAS or YouGov polls was that as a result of research done in January 2024, there is a large amount of both employees and employers who weren't aware of the changes to flexible working requests coming in. So the ACAS survey actually said out of 1,007 employees that were spoken to for the survey between the 4th and the 10th of January, that 7 out of 10 didn't know about the changes. So that's 70% of people that weren't aware. And then in terms of employers, the YouGov poll, which was done between the 8th and the 15th of January 2024, 43% of employers weren't aware. So it's really important that if there are any questions around flexible working changes, that you speak to us or look into the changes further to make sure that you have updated policies and that you're following the new requirements, because it is a statutory legal entitlement for employees. There is guidance from ACAS, so they've revised the Code of Practice on flexible working requests to provide some extra guidance both for employers and employees as to how you should deal with flexible working requests. It sets out the procedure to follow, And it also covers the 8 reasons that I talked through as well on rejecting a flexible working request and how to go about that, including the appeals procedure. So that's a really good starting point for both employers and employees if they have any other questions as well. That's an overview of the changes to the flexible working statutory right. Sophie's now going to talk to you about the changes to paternity leave that have come in April as well.
Thanks so much, Jen. So yes, I'm going to take you through the changes to paternity leave. So it's a fairly straightforward change, really. What the government has now done is that they've enabled individuals taking paternity leave, so that can be the father of the child or the partner of the mother, to take their paternity leave in 2 one-week blocks rather than having to take it all in one go. And the notice requirements have changed. That is it in a nutshell, but obviously I'm going to cover it in more detail now. So the legislation actually came in to force on the 8th of March, and that was to allow people whose babies were due to be born or due to be placed for adoption from the 6th of April to make sure that they could meet the new notice requirements. Okay, so I'm just going to take you through now what the previous position was and what the new position is since the new regulations came into force. So the length of service has not changed. So an employee must still have 26 weeks continuous service by what we call the qualifying week, and that's the 15th week before the child is either due to be born or placed for adoption, if they are to be entitled to take paternity leave. That all remain unchanged. However, Labour has hinted that if they come into power, that they will scrap that minimum length of service. And so that's something to watch out for, which may be a further future change. Now, the length of leave has not changed. It is still a maximum of 2 weeks. However, what has changed is that it can now be taken in 2 one-week blocks rather than having to be taken consecutively. So if an employee wants to take their paternity leave 1 week at the beginning when the child is first born and a week later on, that is fine as long as it's taken within the first 52 weeks following birth or placement for adoption. Now, the previous position was that it had to be taken within the first 8 weeks following birth. So the time frame within which paternity can be taken has really been significantly increased. But what we haven't seen is an increase of entitlement. But just to highlight, this is only statutory entitlement. So, of course, a company can decide whether they want to offer an enhancement or not. And I will cover that in further detail in a moment. So I mentioned notice requirements have changed. So what was the previous position? So previously, an individual had to give notice to take paternity leave either during or before the 15th week before the child was due to be born or placed for adoption. That's been reduced quite significantly now. So now an individual only has to give 4 weeks or 28 days notice of when they want to take their paternity leave, which has given far greater flexibility for individuals to choose when they want to take their leave, rather than having to plan it so far in advance. And finally, the pay entitlement has increased slightly. So previously, it was a statutory rate of £172.48 per week, which has now increased to £184.03 per week. So we had a look into some research that was carried out with regards to people's opinions and viewpoints on statutory paternity leave, because we can see that whilst there has been some change, really, the significant point for people is how much leave they're allowed to take, and that, as I mentioned, has remained unchanged at 2 weeks. And it was found that following a survey conducted by the campaign group called Pregnant Then Screwed, they interviewed 35,800 parents, and they asked about their opinions on paternity leave, and it was found that 60% of fathers took 2 weeks or less paternity leave following the birth of their most recent child, it was found, and 70% did not take their full entitlement simply because they couldn't afford to. Now, I mentioned the statutory paternity leave pay being £184.03 per week. We know the cost of living crisis. We know how expensive life is nowadays, and some people simply can't afford to take paternity leave at that rate of pay. And so there is a massive push for statutory paternity pay and therefore statutory maternity pay to be significantly increased. But we haven't seen any indication that that's actually going to happen. And we also found, in terms of the length of paternity leave, that only 32% of fathers who took 2 weeks or less paternity leave actually felt ready to return to work, which highlights that actually the purpose of paternity leave isn't just for fathers to take 2 weeks off to spend some time with their child. It's a really, really critical time for fathers to spend time bonding with their child, to spend time supporting their partner, supporting the mother of the child, and that really more needs to be done with regards to the length of time they are given off. And finally, there are calls for paternity leave to be increased to 6 weeks at 90% pay, and that would mirror the current statutory entitlement to maternity leave. So just quickly before I finish, some practical tips for employers. As I mentioned, the changes to paternity leave have already come into force. So if you haven't updated your paternity leave policies, I would really urge you to do so as soon as possible to make sure that you're complying with new legal updates for any employees or workers who are taking paternity leave. Consider whether you want to offer any enhancements. There's absolutely no obligation to do so, but obviously offering enhanced pay or enhanced leave to your workers will boost employee morale. It will potentially increase retention rates, so that's something to consider. Offer your HR and management staff training to make sure that they are aware of their obligations and of rights with regards to paternity leave so that they are correctly implementing the policies. And just practical tip, there is no right to postpone statutory paternity leave or request that it be taken at a different time. So with certain types of leave, employers do have a right to postpone it or have a discussion with employees about taking it at a different time. There is no such right with regards to paternity leave. So provided that the worker or employee has given the correct notice requirement, there's no flexibility in that regard. They will be entitled to take that leave when they request to do so. And finally, you may see a slight increased uptake in employees taking statutory paternity leave given the changes, although in reality, it's likely to be modest because the changes really aren't that significant in the grand scheme of things. But again, really important that you're aware of them and that you implement them correctly. So that's it for paternity leave.
Brilliant. Thank you everyone for joining in on the first episode of the second series of the World of Employment Law. Our second episode in the series is going to focus on the new entitlement I mentioned of carers leave. So why that was brought into force in April 2024, what the new entitlement is, and the process for employees requesting carers leave and any notice requirements they may have to give. So we hope you'll join us for that second episode. Thank you.